Court officer, am I audible?
Audible, yes, sir.
Thank you.
ಮೆಮೊ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೀವಿ.
ಇನಿಷಿಯಲ್ ಹೇಳ KTY ಇದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ ತುಂಬಾ ಗ್ಯಾಪ್ ಆಗ್ಬಿಡುತ್ತಲ್ಲ ಅವಾಗ ಸ್ವಲ್ಪ ಯಾರ್ ರಜಾ ಕಮಲ ರಜನಾ
ಎಲ್ಲ ಟೈಮ್ ಕೇಳಿದ್ರು ಕೇಳ್ತೀನಿ ಅಂತ ನೆನ್ನೆ.
ಕಮಲ ಓ ಅವ್ರಿಗೆ ಎಲ್ಲ ಅಪ್ಡೇಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಎಣ್ಣೆ ಎಲ್ಲ ತುಂಬಾ ಏನು ಇವರು ಈ BC-ನಲ್ಲಿ ಸಿವಿಲ್ ಡ್ರೆಸ್ಸಲ್ಲೆಲ್ಲ ಬಂದ್ಬಿಡ್ತಾರಲ್ಲ ಯಾರು ಅಡ್ವೊಕೇಟ್ ನೋಡಿ ಮಾಡಿ ಸರ್ ಮಾಡಿ ಕೊಡಿ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರನ್ನು ಮಾಡಿ ಕೊಡಿ ಸರ್ ಯಾಕೆ ಅಂತಂದ್ರೆ ನಮಗೆ ಡೇಟಾ ಸೈನ್ ಮಾಡೋಕ್ಕೆ ನಮಗೂ ಅನ್ಸ್ಟಿಪ್ಯುಲೇಟೆಡ್ ನಮಗೂ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ తీసుకుంటాను ಬಿದ್ದು ನಾಳೆ ಕೊಟ್ಬಿಡೋಣ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಗೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಟ್ಬಿಡಿ ಸರ್ ಏಮ್ಸಿ ಅಂತ ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಫ್ರೆಶ್ ಇದೆ
ಎಫ್ಆರ್ ನಂಬರ್ ಆಗಿದ್ರೆ ಕೊಡ್ಬೋದಾ
ಅಲ್ಲ ಸರ್ ಎಫ್ಆರ್ ಯಾವ್ದೋ ಫ್ರೆಶ್ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಮಗಿಲ್ಲ ವೈ ದಟ್ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಮಗಿಲ್ಲ
WP ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಾಡಿ
ನೋಟಿಸ್ ಆಗಿತ್ತು ಮತ್ತೆ IML ಬಂದಮೇಲೆ ಕೊಡೋದಾ ಸರ್
ಓನ್ಲಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ನೌ ಇಟ್ ಇಸ್ ಫೈಲ್ಡ್ ನಾಟ್
ನೋಟಿಸ್
ಕೊಟ್ಟಿದ್ದೀನಿ
ನೋಟಿಸ್
ಆಗಿಲ್ಲ
ಅಲ್ಲ ಇದೆ ಇಟ್ ಇಸ್ ಆಲ್ರೆಡಿ ಪೋಸ್ಟೆಡ್ ಬಿಫೋರ್ ಸರ್
ಒಂದ್ಸರಿ ಪೋಸ್ಟ್ ಆಗಿದೆ
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಓನ್ಲಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
ಪೆಂಡಿಂಗ್
ನಾಳೆ ಡೇಟ್ ಕೊಟ್ಬಿಡೋದು ಸರ್ ನಿಮ್ದು ಪೋಸ್ಟ್ ಆಗಿದೆನಾ ಗೊತ್ತಿಲ್ಲ ನೋಡೋಣ ಅಂದ್ರೆ ಯಾವುದು ಏನಿಂಗ್ ರೆಡಿ ಇದ್ದಲ್ಲಿ ಗೊತ್ತಿಲ್ವಲ್ಲ ಏನ್ ಮಾಡ್ತದೋ ಡಯಟ್ ಯಾವ್ದದು?
ಇದೆ ಎಷ್ಟ್ರಲ್ಲಿ ಆಗ್ತಿದೆ?
4 ಇದೆ. ನೀವು ಬನ್ನಿ ಸರ್, ನಿಮ್ದು ಇದೆ ಪಾಸ್ ಮಾಡಿ, ನೀವು ಡೆಡಿಕೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಎಕ್ಸ್ಪೋರ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನೀವು ಒಂದು ನಾಳೆ ಕೊಟ್ಬಿಡು, ಅಮೌಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗುತ್ತಂತೆ, ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಚೇಂಜ್ ಇದ್ರೆ ನಾನು ಒಂದು ಸೈಡಲ್ಲಿ ಬರೀತೀನಿ.
ತಾಳಿದೆ ಬೋರ್ಡ್ ಏನು ಕೊಡಿ.
ಇವಾಗ ಕೊಟ್ಟಿದ್ದು ಅದು ಡಿಸ್ಪೋಸ್ಡ್ ಮ್ಯಾಟ್ರು.
Like 2 matters for being spoken to. Small correction.
Family court.
Yes. Yes.
Allowed for the preliminary hearing. Only notice was issued and no waiting order was.
Which year is that? Which year is that?
2024.
Notice is served on the respondent?
Yes.
Yes.
Madam,
My lords, respondent has submitted two maintenance, family court myself. Not yet clear, listed 1.5 year.
Hmm?
1.5 year. Not yet listed.
Matter is
It's
not
come.
fixed.
Yes.
My lords, the matter pertains to two petitions arising out of two common orders. The minor child suffers from vesico-uretary junction, which is a congenital disorder. The family court has passed two adverse orders against the two set of common orders on 4 IAs, preventing the child from not leaving Bangalore because the interim order stated that the child could not leave Bangalore due to specialized care required for the child, constant specialized care. Anywhere in Karnataka, let alone to her maternal house, because that was the original prayer. But the family judge has granted permission to travel throughout Karnataka, and the petitioner father cannot have custody during the weekends because there's no prior notice required to be given by the respondent wife, and even given the medical needs of the
Yes.
child.
getting of interim order, my lord, wife's petitions. Both petitioner and respondent are senior citizens, my lord. Petitioner is husband is enjoying the interim order without paying a single pice. He is enjoying the benefit of interim
Yes.
order.
The part matter. You not order for
Monday. Monday. There or Monday.
the visitation has not been taken.
Yes. Yes. Page with adjournments.
This page wise adjournment, list 1, page 1, serial number 2, page 2, serial number.
Hmm. Give it.
ನೋಡಿ ನಮ್ದು
Just a
ಆಗಿದೆ
depth
ಫಸ್ಟ್
more.
ಚೆಕ್ ಮಾಡಿ
Lordship,
ಪೇಜ್ ನಂಬರ್ ಕೊಡಿ ಅಮ್ಮ ಇಸ್ಕೊಳ್ಳಿ
What is that?
This is one was honored by your lordship regarding the event, my lordship. It was ordered in 8 months back about for 2,40,000 rupees, and it should be settled, and 10,000 rupees per month should be given by the son to the mother. And then the lordship gave 8 weeks time for settling the amount. Even after 8 months, even the 2.4 lakhs is not settled, my lordship. So that is one. Other thing is regarding the family court matter, my lord.
Yes.
page wise adjournment, list 1, page number 1, serial number 2, page 2, serial number 3 to 6.
We withdraw the matter.
A memo is seeking to withdraw the petition. The memo is taken on record and the petition dismissed. The RPFC is dismissed as withdrawn. Yes, next.
Page number 3, serial number 7 to 12, page number 4, 13 to 15, page number 5, 16 to 20, page number 6, 21 to 24, page number 7, 25, 26, page number 8, 27 to 37, page
Serial number 37, my lord. Serial number 36, my lord. 6 adjournment for admission. Short adjournment, my lord,
Who appears as the respondent?
for petition.
Ravi Kumar, NR.
Have you informed the other
Serial
side?
number 37. That's it. 36 one. Serial number
36.
36.
Anish Acharya.
No, have
Taresh.
you informed the other side?
Taresh.
No.
Wait for your turn.
Serial number 35, my lord.
Hmm.
I have informed the others. I'm for the respondent.
At the request of learned counsel, the respondent lists this matter for 2 weeks. Yes.
Page number 9, serial number 38 to 46.
Milord, serial number 40, Milord. Serial number 40 and 41, Milord. I am not having a good health, Milord. I am feeling not well, Milord. Start at next week, Milord.
Yes.
40 and 41, Milord.
40 and 41 at the request of the council that is not well. This is matter after 2 weeks, give a date.
Grateful.
Sir,
Grateful.
44. It's coming up for admission. List this matter after a week. Yes. Why that mic is not working? Nobody is using
he's
it.
working.
Suit infrastructure.
They have not.
Which one?
Serial number 42. Mutual divorce ಆಗಿದೆ my lord. 42.
It has become infractious.
Yes.
Land counsel the petition submits that already the parties have obtained the mutual consent divorce and nothing remains to be adjudicated in this petition. Accordingly dismissed as infractious. Yes.
Page number 10.
Serial number 15, my lord. Serial number
Page
15.
number.
Use the mic.
Mike use medical.
Serial number 15, ma'am. I authorized.
Serial number
15.
15. Petitioner. Withdraw, ma'am.
Take that.
is called
Withdraw, ma'am.
50.
Family court settlement ಆಗಿದೆ ma'am.
It is stated that the memo is filed stating that MC number 250 of 2007 before the 4th additional principal judge family court, a settlement is arrived between the parties and the writ petition will be dismissed as withdrawn accordingly. This writ petition is dismissed as withdrawn.
Page number 10. Serial number 40. Serial number 47 to 50.
Serial number 48, my lord. Thanks for calling the memo, my lord.
The memo is filed stating that the relief that has been sought by the petitioner before this court is already granted as the suit is, as the petition is transferred and nothing serves a consideration. Accordingly, dismissed as withdrawn. Yes.
Serial number. Page number 11.
47. NOC Wakalat on behalf of at the request of the council, it is submitted that the council has recently at the so-and-so at the NOC Wakalat and request time post after 2 weeks, give a date.
Serial number. Page number 11. Serial number 51 to 60.
My lord,
57.
serial number 56, my lords. I am for the petition in this matter. Matter has become infectious, my lords. Hence I am.
Appear for the respondent, my lord. Not aware
Matter
of
has
it.
become infectious. Move it, matter. That's one target.
I don't have the instructions. I will seek the
No,
instructions.
this petition.
I am the petitioner, sir.
Okay, the respondent in the.
Right. When he wants to withdraw his petition, you cannot have any objection because you are not the petitioner here.
My lords, this petition was filed, challenged the IA, my lords. The final matter is disposed of.
It is submitted to the main MC itself is the MC or criminal.
MC, my lords.
MC itself is disposed of. Learned counsel the petitioner submits that the main MC itself is disposed of and nothing serves a consideration in this petition. Accordingly, the petition is dismissed as infractious. Yes.
Please, miss. Dead.
Serial number 57, my lord. I'm for petitioner. There is a possibility of settlement, my lord. It may be called up for 2 weeks. Inform the others.
The other side,
Please, my lord. I have given a proposal and informed the other side, my lord.
57, it is submitted that there is a likelihood of settlement. List this matter after 3 weeks. Yes.
Lordship,
Interim
serial
order may
number
kindly be
59.
extended, my lord.
Lordship,
Look at it,
serial
the
number.
interim order is there extra.
Please, ma'am.
Yes.
Serial number
Right now.
59, your lordship, we are for the petitioners. We pray that the matter may be adjourned, your lordship. Kindly give us 2 weeks time, Your Lordship. The file's
Inform
been
the other
misplaced.
side.
I've informed the office to drop a message, Your Lordship. The number which we found on the wakalats, we'll drop a message on that, Your Lordship.
This is matter next week
Much obliged.
at the request of counsel for the petitioner. Yes.
Page number 12, serial number 61.
Yes. Call the list.
List number 1, serial number 1.
Please, my lords, I appear for the respondent. My lords.
When the matter came up yesterday, then counsel for the respondent submitted that the set of papers were not served on the respondent. And as there was no representation, the matter was directed to be listed today under the caption for dismissal. Even on 28/4/2025 also, there was no representation on behalf of the petitioner, and the matter was directed to be listed after summer vacation. Today, in spite of the fact that the matter is listed on dismissal, there is no representation. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution.
Serial number 2 for order, Sachin BS. Sachin BS for petitioner, HV Manjunatha. Non-filing of application.
This is matter, no representation for dismissal tomorrow.
Serial number 3 disposed. Serial number 4. Serial number 4.
There is no audio connectivity, my lord. I'm sorry.
Call those people. Ask them to come. Ask them somebody to be here. Give that.
Since last 4 or 5 years, I was not in touch with him.
No, like what is the information when he died?
I'm told that he died.
Then counsel for the.
Can it may be dismissed and steps not taken.
Then this submission need not be recorded.
Please.
It is submitted with the land counsel for the petitioner that as per his instruction, the petition is no more and he is not in touch with him from the last 4 years. And further, this petition is of the year 2017 and so far no steps are taken for issuance of notice on R1 and R2. In view of the same, the petition is dismissed for non-prosecution.
Serial number 8. Vijay and V.
No representation for dismissal tomorrow.
Serial number 9. Serial number 9.
Same order.
Serial number 10.
Week's time, I apply the application. Week's time,
A week's time.
Please.
For complying with office objections, default order.
Please.
Serial number 11. Gagan Raj.
The petitions in this case, my lords. Lords, we have filed a petition challenging the 125.
What about the non-compliance of objections?
I'll file it, I'll comply, my lords. A week's time, my lords. Meanwhile,
No, nothing. We will not grant any order at this stage. If you are ready to do it, I'll take it up day after tomorrow also.
a week's time, my lord.
A week's time for complying with office objection.
Please.
Cell number 12, Deepak BR.
No representation for dismissal tomorrow.
Cell number 13, Dwaresh Shah, addressee deceased.
For dismissal tomorrow. Next.
Cell number 14,
I appear for petitioner, my lord. 2 weeks time for the
Shivram is-
compliance.
What is this on IA number 1 of 22 for modification of the order dated 8/5/2018?
Divorce has been granted, my lord. Kindly give 2 weeks time to
Why
comply.
2 weeks time in this matter for complying the office objections on IA?
1 week.
Finally, 3 days time is granted for complying the objections
1
on
week
IA
time, my
number,
lord.
IA number 1 of 2022. If the objections are not complied with, IA shall stand dismissed without further reference to the court. Next 15.
cell number 15 disposed. Cell number 16, Ranganath NH, furnishing of PF cover.
Same dismissal, no representation tomorrow.
Cell number 17,
Week standard.
A week's time. Yes,
Cell
same
number
with the
18.
default order. In all the cases, time and default order.
I appeal for the petition in this case, my
18.
lords. In this case, office has raised an objection that I have not served the copy of the IA in there. So we don't know the details of the
Rectification
advocate
of office
also.
objections for stay.
Yes, my
That is
lords.
copy served, acknowledgement not filed.
Yes, acknowledge it, we don't have, my lords. So if the advocate is appearing, I could have served the copy also. Don't have the thing also. In this case, family court has passed an award, interim maintenance award, my lords, creating a charge on the property of the mother-in-law. She is not a party to the proceedings.
is this
Challenging
copy served,
this, I have
acknowledgement
filed in
not
this
filed?
affidavit.
Why will this, there is an order to serve the personal notice to them? It will be a, why will they serve an IA?
Directed to survey a copy of so respond. The previous
That there is no counsel appearing. No, there is a counsel for NM, so and so for R1.
Not getting, we'll collect the details and we'll send it by post.
So that you
my
have to do
lords.
it. No, it's
We'll share.
2021 repetition.
Yes, my lords.
There's no point in keeping the land counsel for the petitioner.
I'm,
Sir shall serve the copy
file
of the IA, that shall serve the copy on the counsel appearing for respondent, number 1, within a week, or else, and shall file acknowledgement to that effect, or else IA stands dismissed.
I may be permitted to go through the records, my lords, to
Tell
get the
number-
address of the other side, advocate.
Yes.
Cell number 19, Kamath and Kamath for petitioner, RS Ravi.
For dismissal tomorrow.
Appear for the petitioner in this case, my lord.
Which case?
19, my lord.
Yes.
My lord, in this case, the petitioner is the wife. She
No,
files-
what happens furnishing of so and so to issue notice to the respondent for second time?
No, respondent, is it not respondent? Respondent is aware, my lord. Only one respondent is there. They have already filed Vakalatnama, my lord.
So that is their problem to look after their case. Land counsel for the petitioner is present. No representation for the respondent. List this matter tomorrow. Yes.
Cell number 20,
The petitioner in the
cell
case,
number
my lord,
20,
for having the copy.
Mahabaleshwar. City
Copy now received.
Land counsel for the petitioner has served the copy on the counsel appearing for the
Arrears of
respondent.
amount is
Huh?
due, 20 lakhs arrears of amount is due, my lord.
Please keep that mic proper and speak in the mic.
Arrears of amount, interim order passed by the trial court. They are not paying since from 19.
Oh, we'll just see. We'll just see what is the matter. Then we will know what is the order impugned. My left for the impugned order.
My lord, page number, it's impugned order, annexure G, my lord.
Respondent is entitled for interim in maintenance of 20,000.
Yeah,
Date
20
of the
plus
order
10.
till final disposal of the petition and the minor children educational expenses at the rate of 10,000 per month.
Yeah.
Each per month.
Yes,
So now it comes to 40,000 per month.
30,000 was passed in the year
No,
2000.
10, 10, 20,000 and 20,000 to the wife. It
My
comes
lords,
to
the-
40,000. Then what is the interim order passed by this court?
December 2019, my lord.
1 minute. Well, no interim order.
No interim order, my lord.
And this is order is passed when?
2019 December, my lord.
Then you are not moved. You are not filed the EP.
No, my lord.
Why?
My lord.
Why? There is no stay from this court.
No.
Then why were you keeping
As
quiet?
pending of this court.
How does it matter? No, the whole purpose of granting stay is for that. And if the court is not granting stay and you're assuming that you cannot go forward, then it is the problem of your client. You should have filed the EP by this time.
My lord.
Yes.
My lords, I'll take to you
No, you
annexure
don't,
H, my lords.
there is no stay from this court.
No, my lords.
And from 2021 to 2025, you don't comply with the order of the court.
Yes.
Then why should this court hear your matter now?
My lords, the thing is, the respondent is very much aware. The respondent can take all the expenses by herself itself. Kindly see annexure H and G, my lords. We have
An
produced
order
the
is-
partition deed and the mortgage deed. my
Sir,
lords.
please understand, an order is passed by the family court. You filed a writ petition in the year 2020.
Yes,
You have
ma'am.
not taken any steps to get your IA heard by the court. Till now, stay is not granted. When the stay is not granted, and from the last 4 years, you have not paid any amount to her, why should we hear your petition? When you do
My
not have
lords,
any
the
respect to the
petitioner
orders
is
of the
not
court,
earning that much of amount. The petitioner is not earning that much of amount per month, my lords.
so that's all the more a ground for you to raise on your in your IA. That means you're all right with that order.
No, ma'am.
Will not hear unless and until I will clarify that that he can proceed with the matter, and I'll also direct such application filed by him shall be expeditiously be heard by the court. His EP. So what are you going to pay right now?
20 lakhs, my lord.
My lords,
Within 1 minute, within a week, what is the amount your client is going to
my
pay?
lords, I'll seek
Then
instructions. my
then we
lords.
will hear the matter.
I'll seek instructions. my lords.
Get instructions, short pass out. It will be called, yes.
Pass over. Cell number 21. Cell number 21. Kavita D. Furnishing of PF cover for
No representation for dismissal tomorrow.
cell number 22.
Post after service of notice.
Lord, I'm appealing to the respondent. I've been served a copy.
The
my lord.
direction of this honorable court, I served the copy to the learned counsel who is
Yes, sir.
appearing
I've been
before the
served a
trial
copy
court.
today, my lords.
Yes.
Lords, one request. My lords, in this matter, petitioner and respondent are both senior citizens, and the petitioner, in fact, is a practicing advocate of your lordship's parent high court. If your lordship is able to accommodate us in chambers, my lord, some settlement might happen in this case.
Because
No, even if he is not an advocate practicing in my parent high court, still the court will accommodate.
Please, my
You
lord.
have to tell that. Doesn't matter whether he is from my parent high court or Karnataka high court.
Apologize, my lords.
What do you say?
my lordship kindly give us short accommodation. If they are ready, we are ready on the main matter itself.
When he says that if there is a scope for settlement, why do you say that?
But we already given that in the family court matter itself, we given one for proposal, but they did not agree for that.
What is your proposal?
If I will get my colleague is online, please, my lordship.
With your lordship's kind permission,
Yes.
lordship, we had already, in order to save time in regard to also the age of the parties also, we had given it to the local council who's also appearing right now. We had said that they did not file section 25, but still because the parties are almost around 69 and 72. We had given an offer of around a flat, which is around 2.5 to 3 crores.
Hmm.
Now they, after
for
we
the wife.
gave that.
I'm for
No,
the
no,
wife. I'm for the wife.
Pay for the husband, your lordship. And after that, they filed a DVC case wherein they are claiming 5 to 6 crores, sir. And this was after a span of almost 40
What is the
years they have
age of the
initiated.
wife?
69 years.
69 years, sir.
69.
69, my lord. 40 years they have been married, my lord. 72.
And she's
If
not
I-
happy with
If
No,
I
my
may, your
lords.
lordship.
apartment.
Lords, that is not the reason, my lords. Petitioner has not come in person, my lords. Only through advocates, some instruction they had given that, we are ready to settle these matters.
When your party is ready to.
My party is here in Bangalore, my lord. It is their party who will have to travel.
Yes.
I
When will he come? Mr. Prabhu.
am Prabhu, my lordship.
Sure,
My
Prabhu.
colleague is Shikhar.
Yes.
Your lordship, this month, whenever this honorable court directs us, we'll appear.
Monday.
Please, my lords.
Both the parties shall appear before the court on Monday and in the chambers at 5 o'clock.
Grateful.
Yes,
Much
23.
obliged, your lordship. Much obliged.
In chamber at 5. Yes, 23.
Cell number 23.
Your Ladyship, for the petitioner father, the petition has been rendered infructuous because it was with respect to summer vacation. We achieved the interim custody.
My lords, here one submission. I just filed a memo regarding the order which they have not complied. On 19 to 23rd, they are supposed to come and meet the children. That is the order has been passed by this honorable court, which they have not complied, my lords.
It's a part compliance. The reason is he had to rush back to Bombay.
They have
2 days
just
we could
made
not.
ourselves not to go out of the Bangalore. With that condition, we are just holding my children not to go anywhere. Though with that, they have not at all complied and they have not come. The order has been passed from the.
It was informed. It was informed
What
well
are
in
the
advance.
dates you're supposed to meet?
19.
We had to meet from 16, 17 till 19.
16,
They last.
17, 18 and 19.
Yes.
You're supposed to meet. What is the duration?
Yes.
Time?
It was between 2 o'clock to 5 o'clock.
Uh,
And he has not complied only the last 3 days.
That is, out of 4 days, 3 days he didn't.
Yes.
Only 1 day he went.
No, 2
So
days. 2
when
days.
when it is not when he's not able to meet the children,
They went.
was it communicated to?
It was communicated. He has told her.
5 days, my
Nothing
lord.
was told.
Just going and coming, going and coming. Our
That
attendance
is-
is there in the mediation center. In the register book, we have signed and come. With the 2 children, swing childrens, we are just going along with that. Wait for another 1 hour, 2 hours, and we are coming back every day,
That
5
is,
days.
that is outrageous, Your Ladyship, because he has sent her mail. She has blocked him. Everything has been communicated.
Not,
In
no,
fact-
no,
in
my
fact,
lords. It's not blocked.
We have proof of that. In fact, the first time the orders of the Honorable Family Court were not complied, that's why this Honorable Court gave injunction and orders to this effect. Please understand where it went. And this last order, 3 days they have not complied. Parents are here, grandparents have come all the way from Bombay. He's not from Bangalore. They were camping in Bangalore. And they have complied with the orders to the extent of 18. After that, they could not. I'm submitting that.
My lords.
No, advocates are in touch. If
Absolutely,
the wife
ma'am.
is,
It's
if
communicated.
the wife is blocking or has blocked him, that's why he couldn't communicate. You could have communicated to
We
the.
have sent it to the advocate
No,
also.
no, my lords.
He
It has
also
not
doesn't
been
receive
sent.
it on
Let
WhatsApp.
them, let
I will
them produce,
demonstrate
let
it.
them produce, my lords.
I will demonstrate. That is not the point here. The point is to raise something now because we started bonding with the children. We managed to keep her out, and the director of the Honorable BMC was
Not at
directed to facilitate interaction with the father. That we have achieved. Now the petition is infructuous. I will leave the merits open with respect to what I have to do in the family court. This is a not
Lords, this is a-
genuine issue which is to be agitated at this stage. If they have grievances, we have recourses to it.
When they seriously instructed us not to leave the Bangalore and they have taken the stay and everything, now they say that that is not a serious decision. They themselves has taken the order which they have not complied.
Petition is filed.
I can pass on the email copy if required. On 19th May itself, they were informed.
The writ petition is filed questioning the order dated 25/4/2025, A9 number 12 and JNF number 35 of 2022, passed with the third additional principal judge, Family Court, Bangalore, whereby the court had permitted the father to visit the children during summer vacation in the child visitation room on 5/5/2025 to 9/5/2025 and 12/5/2025 to 17/5/2025 between 2 p.m. to 5 p.m. in calm and peaceful manner. And the mother is directed to hand over the custody of the children between 2 to 5 p.m. to the father on the dates mentioned above, to enable the father to spend time with the children without causing any disturbance or interference in any manner. And also, father was directed to take care of the children, keeping constant supervision over the children, and to meet the needs of the children, considering their welfare and its consequences. Now, what I'm not able to understand is, you have come before the court with regard to this. The same order is passed here.
I'll
What else-
explain.
what else you have got?
I'll explain, Your Ladyship. The order was passed by the family court in her presence, 2 to 5. We challenged it. Why? Because she did not comply for 5 to 12. She was never there. And we came before this honorable court. This honorable court then said she has to comply with the order and she has to remain outside the premises. That is the direction to the
No,
BMC
that is
director.
not that. That is
And
not
that
that.
is what was implemented.
No, that is not
That is
that.
the injunction.
No, please,
Yes.
what is this? How your client continuously can submit? You have to at least instruct her.
She's insulting the council by standing there. And now, Your Ladyship,
No,
what
please
happens?
wait, let me see what is the order.
Please. And she was never allowing the grandparents. So there's a specific order to that effect also.
Where is that? Please point
The
out
grandparents will join. It is the order dated 15/5, last para. The petitioner along with the parents may visit.
to the order. Where is the grandparent?
Parents, along with the parents, means the parents of the petitioner.
Hmm.
Please see, will visit on 16th and 17th. We managed 2 days for them after 3 years of.
You said that the mother shall not be inside.
Yeah, that is here. That is here, Your Ladyship, in the previous order, because the same was continued. Please see. Learned counsel for the petitioner, para 2, submits that respondent has not complied.
So you're reading
And-
which
and
order? Dated.
I'm reading
Dated.
the previous order dated 13/5, which
yes.
was continued. Para 2, may I read?
Yes.
Learned counsel for the petitioner submits that the respondent wife mother has not complied the said order. He further submits that the order directs the petitioner father to visit the child on the supervision of the respondent's mother, which respondent mother,
Submission.
correct, which should not be conducive, hence seeks for modification. As regards the modification of the aforesaid, learned counsel for respondent seeks short accommodation to file objections. As regard the allocations of keeping the child present, he submits director of BMC be directed to supervise in presence of the children.
Where is
Further.
that order that mother should not be there?
The director of BMC has been told to supervise, which means she did not.
Supervision, that doesn't mean that she shouldn't
But
be
he
there.
ensured that. The director ensured this.
But that's not the order at all.
No, that is the intent, Your Ladyship, because they thought time. If she is there, we cannot have bonding.
What is the intention of the judge shall be reflected in the order, not in the submission.
No, I have submitted, Your Ladyship. That is the whole
Sir,
point.
order should indicate. I should be able to read from the order. That is not there.
That is what I'm inferring from para 5. That's why she was kept out.
The code only said, how the visitation is going on, he should supervise. They nowhere they said that the mother should be out of it.
No,
They
my
made
my
it, my
complaint
lords.
has been registered here
They are
in terms
forcefully-
of how she's
Every
interfering.
time, whenever you make your submissions, we'll record your submission, their submission.
Correct,
Ultimately, what is the order is the order of the court.
Correct, Your
So
Ladyship.
we can't read your submissions
Yes.
and the order.
But we ensured that over those 3 days, that she was not inside.
That
She
is
was kept out.
unfortunately, the director has not understood the order in the way that is passed. Anyhow, yes. What did you write? You didn't write anything. That's the problem that's why if all of you are here, you will understand what I'm referring to. Because if you stand there, you don't know whether I'm. The present writ petition is filed. Agreed with the orders passed in I number 12 and GNWC number 35 of 2022, dated 25th April 2024. The family court had granted visitation to the father in the child visitation room on 5/5/2025 to 9/5/2025, on 12/5/25 to 17/5/2025, between 2 p.m. to 5 p.m. And the mother was directed to hand over the custody of the children to the father between 2 to 5. And also directed the father to take care of the interests of the children. Agreed thereby, the father is before this court. This court, though it is submitted that it should not be with the supervision of the mother, when it comes to the order, an order is passed by this court on 13/5/2025. The court had already recorded submission of the respondent that the director of the mediation center Bangalore to be directed to supervise the presence of the children. Accordingly, the mother was directed to keep the minor children present before the director of mediation center Bangalore between 2 p.m. to 5 p.m. That is on 13/5/2025 and 14/5/2025, and directed the matter to be listed on 15/5/2025. On 15/5/2025, the court had made the similar arrangement on 16/5/2025, 17/5/2025, 19/5/2025, and 23/5/2025. Land counsel appearing for the petition submits that the writ petition is filed only with regard to the visitation during the summer, and as such the petition has become infructuous. It is submitted become infructuous. Land counsel appearing for the respondent submits that, having obtained an order except on 16/5/2025, on 17/5/2025, 19/5/2025, and on 23/5/2025, the father has not come to the mediation center, child visitation center, and the mother was made to, and she went to the same along with the two children, and she is made to wait. According to the land counsel for the respondent, the intention of the father is to see that the mother will not travel, and she should stay in Bangalore. That's the reason, even after obtaining the orders, he has not chosen to come to visit the children, nor the same was informed to them. Next para. In response to that, land counsel for the petitioner submits that the mother had blocked the father as such. He has in fact sent the email, and he has been communicating that he was not in he is not in a position to come for the visitation. Where from he has to come?
Bombay.
So every day he'll be knowing it, or
no? He was camping in Bangalore for 21 days to make all these arrangements. They were absconding. She was out of Bangalore.
No, I said
yes.
16/5 you visited.
He visited. 17 also he visited.
No, you said only 16.
No, 17 also.
He has visited on 16
and 17.
5 and 17/5/2025.
On 18th holiday,
19 to 23.
he could not. On 18th
from
emergency
19 to
arose.
23, he could not visit. Then when did you communicate to her?
He has communicated on 19 morning itself.
Saying that you will not.
I am not able to come. I will tell you when I can come.
It is stated that he has already communicated by
at 8 a.m. in the morning.
By email that he is not able to visit the children between 19/5/2025 to 23/5/2025.
But you have not reached.
Denied by the land counsel appearing for the respondent.
Mail has not come to us.
Mail is not received.
She has to say it.
This court at this stage cannot go into all these facts, whether the such mail was received by them or not, and by them. As far as the writ petition is concerned, as it is pertaining to the summer vacation, and as already the dates that were granted by even by the trial court by way of the impugned order have elapsed. Court do not find any reasons. There are no further adjudication is required in this writ petition. However, with regard to the lapses on the part of the father, it is always the respondent, the petitioner and the respondents are always are at liberty to agitate before the court and to come to facility so that the court will be able to understand the conduct of the parties also.
In the memo, I've sought all merits to be kept open, all contentions of merits to be kept as per the memo.
Yes.
Much. The memo may be taken on record, Your Ladyship.
Whose memo?
That's my memo for being
Copy
in
has not, sir.
Here.
A memo is filed stating that dispose of the instant writ petition by keeping open all the contentions, and the same is taken on record.
Highly obliged.
Yes. This. Anita. Yes. You always tell the stenographers to stand here. That they also won't be understanding, whether I'm talking or I'm dictating to them. So if they stand here, they'll be able to understand. Yes.
Cell number 24, hearing on interlocutory
Yes,
replication.
I am for the petitioner in this case, my lord. Here the petition for enhancement of the 125 order filed by the wife, my lord. 300 days, 300 days, 300 days. My lord. So, may kindly condone the delay, my lord.
What do you say about the delay?
My lord, I will file objections. Also, my lord, the petition was ordered to be served on me. What he has done, my lord, the draft petition is emailed to me, and some certified copies are posted by post, my lord. He has to serve the copy as filed.
No, already served, my lord.
The complete set
My
of
lord,
papers.
complete set also
He is
served. my
not.
lord.
So how do we decide?
Already
it now?
I get the
Then
acknowledgement.
do it again. It doesn't matter.
Already I
The
get
entire
the
set of
acknowledgement,
papers
my
to the
lord.
non-counsel appearing for the respondent within 2 days, and from there, within 1 week, objections shall be filed. List this matter on 17th.
May kindly 9th or 8th may be, 9th or 10th may be date may be given, my lord.
Yes.
No, I will file objections.
Please.
Cell number 25,
For the
Aishwarya R.
one petition, my lord, I am for the
petitioner, my lord. Consequence of the petitioner, my lord. He is not keeping well.
No, my lord, kindly see, my lord, I am last person to oppose this type, my lord. This honorable High Court, my lord, already heard the matter, and so many sitting, my lord, for the negotiation. After that, my lord, they filed one more petition, and they tagged this petition to that petition and saying that it is not a part heard before the another bench. I said that, my lord, I submitted before the same court and released from that the clubbed matter. And in that matter also, this honorable High Court to pass an order to serve the copy. They are not at serve. Only to avoid this bench, my lord, they are one or the other reason they are submitted before this honorable High Court. Last occasion, my lord, last occasion.
Why they want to avoid this bench?
Yes, my lord, because of this is, my lord, I want to submit. Because the connected petition, they submitted in another bench, saying that, my lord, is not part heard. Even though this honorable High Court, my lord, is heard the matter and so many negotiations in chamber, even then, my lord, they argued the matter before the another bench, saying that, my lord, is not a part heard. When I showed the order sheet, then only they said that, my lord, is a part heard. And even then, my lord, they are saying that, my lord, is not part heard. And kindly see the order sheet.
Dated? Dated?
Dated, my lord. In one petition, your lordship already dismissed the petition filed by the petitioner to against the medical officers. It's a dated 18/9/2024. Your Lordship passed detailed order
18/9.
2024.
You are referring to 25.1.
Referring my Lord
No, there.
20817.
Give that. Give the order sheet in
Yes,
that.
ma'am. 4987, I think. 18/9, sir.
20817.
Yes.
20817.
Let it come tomorrow. Liz Market tomorrow.
Please.
Tomorrow.
Day after tomorrow, my lord. It's not day after tomorrow.
Day after tomorrow.
26. Serial number 26.
Your Lordship, serial number 26 has become infructuous. This was on an application in the MC petition. Now the divorce by way of
MC itself is disposed.
by way of compromise. It was disposed and challenged, and thereafter there was a compromise, and then it's been
The
confirmed.
present petition is filed, assailing an interim order passed with the family court. Thereafter, the MC itself is disposed of, and against that, the MFA number 3131 of 2023 is filed. That came to be disposed of
By way of a compromise.
by way of a compromise, and the marriage between the parties, which is performed on 18/12/2010, is dissolved by decree of divorce by mutual consent. Then council submits that in view of the same, in view of the order passed in MFA number 3131 of 2023, dated 20th December 2024. This petition has become infructuous. Accordingly, dismissed as infructuous.
Great.
Serial number 27. Manjunath B.
Petitioner Malad, mediation ended in failure. Originally, the petition filed by the petitioner seeking by the husband seeking divorce, wherein even the mediation also we proposed that you should be ready to take wife back, but it was not fruitful. That proposal was not handed fruitful.
What is the impugned order?
The impugned order for granting interim maintenance of 20,000.
How much? 20,000.
20,000.
What is the income of the husband?
Husband is 75,000. Wife was also earning 18,000 salary.
No. 1/8 or 8?
18,000. 18,000.
So husband is earning 70.
Yes.
Wife is earning 18.
18.
How much is granted now?
20,000. It's a case where Malada, it's a desertion by the husband or wife herself, and she has herself declared before the Police Commissioner that
MC is filed.
MC is filed by husband, wherein on the ground that she herself deserted the husband.
The ground of desertion.
Yes, please. And the cruelty also. And she deserted, and even she, in the Your Lordship, even in the objection filed by the wife to the main petition, her counterclaim is also for divorce. Your Lordship, I'll take Your Lordship kind of.
Which ground?
Malad?
Divorce on which ground? By the counterclaim.
Cruelty. Your Lordship, I'll request my last to kindly page number 49. Our objection statement, prayer.
1 minute.
The relief sought for by both the parties are one and the same. The only thing is that she claimed that my petition to be dismissed by imposing compensation.
What do you say?
What my learned friend is telling is totally false. She has no job. She was, Lordship kindly see, she was working as a teacher when the engagement took place. That is in April 2014. The first, she is from Bihar. Now, they were settled at Bangalore. The petitioner is settled at Bangalore. His father is a bank officer at Goa. Now, their first condition is you have to resign the job. She has to resign the job. The marriage took place on 9/5/2014.
9/5?
2014. 203 grams of gold ornaments.
All that will not go into.
Okay,
Now, the
okay.
only issue you have to argue before the court
No,
is
no.
that whether she is working or
She is not working. She is not working.
Then from the order, what is the finding of the court? Let us see.
Finding, that is what. She has no job.
Page number. Come to the impugned order.
Lordship, the page number 88. The relevant portion is at 88. It starts from Your Lordship. 78. The relevant observation with regard to our gainful employment. Page number 88.
Yes.
Printed page 11.
The petitioner, though, has taken contention that the respondent is working as a teacher in Bihar and earns 20,000 per month. He has not placed any document, either to show her employment or her salary particular.
The next paragraph, next.
Which
From third line, Your Worship. He has produced a notarized copy of passbook Banks India. It's shown that the Harati Kumari teacher. Lordship, my respectful submission should be in this case, Your Lordship. As on the date of filing her affidavit towards assets and liabilities, she was gainfully employed. She says that I was not gainfully employed.
So which para you are referring?
I'll take my lord's kind attention.
No, there is no finding by the court with regard to her employment. Where is the finding? Court has not given any finding that she is gainfully
Because
employed.
I produced the document to show that she's getting salary.
Which is the document?
I'll take my lord's.
And where is it referred to?
I produced the assets.
Some bank asset statement and bank statement they have produced, Your Lordship.
I produced the assets and liabilities, my lordship. Madam, it's on the bundle. It is there on record. Akidi, assets and liabilities. In that one, my lordship may kindly see at page number 185. 185.
Yes.
Petitioners filed a written argument before the court below. Along with that, they have produced a bank passbook copy, page number 187. 187 at page number 189.
Yes.
Lordship may kindly see. 28/4/2022, the last one entry. 28/4/2022, 18,000. Next page, your lordship may find on 25/2022, 18,000. Down in the same page on 27/6/2022, 18,000. Just below that, there are two entries. 1,000, 17,000. They themselves was taken it by school authority has removed him and taken the money back. I have filed the objections, additional synopsis at page number 191.
Yes.
Para number 2, my lordship may kindly see. On the averment regarding employment of the respondent as a teacher at Woodstock School, Buxar, stated in the written argument, the respondent submitted school authorities has allowed the respondent to work temporarily vacancy for 3 months.
No.
From
Was
April,
it your stand?
I produced the same bank statement. Only
When you file your objections,
my lordship,
when you filed your application for interim maintenance, have you stated all these facts?
it is subsequent to that. My lordship may kindly see
Not
when
stated.
is my application for the interim maintenance file.
May I request my lords to kindly take the page number 58 of my petition, a liability statement affidavit filed by the respondent, which is on subsequent date. She says that I'm not gainfully employed, I'm not working anywhere.
My
Lordship, kindly
my-
take
my
page
lordship
number
may-
58. After I filed the bank statement,
One minute. Yes.
1 minute. My application for maintenance was 23/12/2021.
23/12.
2021. I have produced a bank statement, my entire bank statement, if my lordship kindly see at page number 198. That is from 13/9/2014 to 17/4/2023. Only two payments. That is April 2022 and May 2022. Otherwise, I am unemployed. It was not on
Your
appointment.
application for interim maintenance is filed on what date?
It was filed on 23/12/2021. It is thereafter for 2 months. It is not on any letter of appointment or any this thing. On leave vacancy for 2 months, I am given a job. 3rd month, I am removed from the job. Otherwise, there is no job.
Yes.
Please, ma'am. My lordship, I'll request my lordship to kindly take annexure of page number 58, wherein she filed an affidavit of assets declaration. It was filed on 12/7/2022.
It is also not your case that as on the date she was filing the application, she was gainfully employed.
My case is
By relying on this passbook, you are also relying on those 3 entries with regard to her salary.
no, even in my state objection to the IA also, I taken contention that she is working.
Taking contention, there should be a document.
The document, your lordship, subsequently I got it.
You got it, but that is only for 3 months in 22.
Yes, because she's working, she's ensured that it's not reflected in the bank statement by way of cash. See, my case is that she still today is working in the same school where she was working before marriage.
Anyhow, if you're able to prove in the course of evidence, then the court will decide that.
Yes, one thing.
At this stage.
My respect to submission is a case of desertion by the wife. Your lordship, kindly take annexure B for a moment.
And for that, her cases is cruelty.
Yes, when the wife herself deserted, when in spite of lordship,
In every case, if the husband says that the wife had deserted, is it a ground for the court not to grant?
she herself admits in the by way of writing.
No, she left the home. She has a reason for that.
My lordship, may kindly see.
My lordship, kindly take annexure B for a moment.
21(3), I file an objection. My lordship, may kindly see how
And
cruelly this lady
her
was
prayer is
treated.
also, lordship, my lordship to submit should be.
One
It's the only case.
year, 9 months, she was under treatment because of the harassment made by.
Yes.
I don't understand. I'm asking him. I'm convinced with the case of the wife. Then if there is anything, is there, I'll ask you.
Please.
Yes.
Lordship, kindly take annexure B for a moment. Page number 23.
No, the issue of desertion cannot be decided now. You cannot plead that. You cannot, when an interim application is pending, it is your case. It is yet to be decided by the court
Yes.
whether there is desertion or not. So you cannot.
No, her own document, which is not being disputed, and she admits that she.
No, will say that document is there, that as on the date when she filed the application, even according to you,
Yes.
none of her bank statements reveal about this 18,000. That is in the year 2022 for 3 months. She has an explanation for that,
Yes.
which appears to be convincing. And if you want to produce some other evidence at a later point.
And
of time,
even, Lordship, even I was unemployed for 1 year because I was terminated from the services. The contract was ended. I was unemployed for 1 year. That was also not considered by the.
When from what
Please.
time you're unemployed?
From April 2012 22 to December 22.
April
2022 to December 2022.
December
22.
April to December.
Yes, Lordship.
And what is her, when did she receive the salary? For which month?
April, May, June 22.
April?
May, June 22 as per record, but she is receiving, my case is that she continue to receive.
I'm only asking
Please,
what is
please.
there on record. What is the material placed by you before the court to show that you are not earning between April and December?
My back statement and my termination letter. I have been terminated in the month of March itself. My termination letter and subsequent appointment in the month of January 23. I got.
We'll do one thing. As far as April, May is concerned,
Please.
And June salary, anyhow, they've taken back as per that.
No, they say that they have taken back. It's withdrawn, amount has been withdrawn, my lads.
We can only look at it from the evidence. So what you say doesn't
Yes.
matter. So for the month of April and May, she's already having the salary on those 2 months. No, leaving that 2 months apart. Then June, July, August, September, October, November, and December. You joined in December.
Jan 23.
Jan. So 7. For this 7 months, we'll say that you need not pay the maintenance, and for this April and May also, and remaining will confirm the order of the trial.
My respect to submit should be in this case, and my leave it to Lordship, sir. Since it's a case of desertion on judgment, I would like to rely on wherein she deserted.
Yes.
I'm just some Lordship is aware. Still, I'm submitting. My wife is.
Yes.
There is no desertion.
Yes.
She herself deserted the husband. She is not entitled.
See it.
The last para, Lordship, page number 7, paragraph 6, Milan. Relevant portion, Milan. Page number 8, from bottom 5th line, Malak, the wife herself has abandoned the matrimonial. Page number 8.
The family court, white judgment dated 19/6/2025.
Yes. It's unmerited.
That the wife had abandoned the matrimonial home
Yes.
on her own will. Your case has not come to that level.
Yes,
That's
yes.
what I'm precisely telling you.
No, my respect submission should be in this case. Yeah, understood, understood. It's on merits. I have no doubt.
Not the
That case
merits,
is
sir.
that case is on merits.
The court shall give some finding must be there from a court
Yes.
saying that you have the wife has deserted the husband. Now in this case, according to you, it is desertion. According to her, because of your
Yes,
cruelty,
that point, my observe.
left the home.
Yes, that plea was not considered by the trial court while passing this impugnment. That's my case ground.
I consider it.
That plea, whatever I have taken, that was not considered.
In that stage, the court cannot consider. Then it is as good as allowing your MC itself.
Lordship, our prayer is also same. Our prayer, Your Lordship, kindly take objection statement, Your Lordship.
No, will not say anything else. Please come.
Our prayer in the petition is also for a same relief, seeking divorce.
I understood the facts, Mr. Counsel. It is in between, it's not connecting. The computer section people are there. Ask them to want to be present here today. The present petition is filed. Where is that?
I'm sorry. Our prayer may once, Your Lordship, page number 49.
I understand. She also asked for divorce.
Yes, yes.
You also asked for divorce.
Divorce.
Then you are on the ground of desertion. She is on the ground of cruelty.
Cruelty.
The court has to decide that.
Because unnecessarily, Your Lordship, every month
So both of you mutually want to have something, you can have it.
we made an best effort to do it, Your Lordship. And trial court may be directed to dispose of the matter within a span of 3 months or
Which
6
is
months.
MC?
2021, Milan. 21,
Which is the court?
Bangalore Family Court.
Bangalore court, we cannot direct.
No, its evidence is completed. My evidence is completed, man.
Cases which are
No,
pending in
my
Bangalore
evidence
High
also completed in that case, match.
agreed with orders passed in I number 3 in MC number 1331 of 2021 dated 12th June 2023, whereby the family court had granted maintenance of an amount of rupees 20,000 to the wife from the date of filing of the IA, that is from 23/12/2021, and a one-time litigation expenses of 10,000. The husband is before this court. Land counsel for the land counsel appearing for the husband submits that wife is gainfully employed. She is working as a teacher. She is earning an amount of rupees 18,000 per month. Full stop. It is submitted that the bank statements that are filed by him before the court clearly shows that she is gainfully employed. And the other fact that he lost his job in the month of April and again joined in the month of June, and he was not having the means to take care of himself. That particular aspect was also not considered by the court. Further, it is submitted that the wife had deserted the husband, and on the ground of desertion, he has filed this application. He has filed the MC seeking divorce. He submits that the wife files a counterclaim seeking divorce on the ground of desertion. When the wife has deserted the husband, she is not entitled for maintenance. He had relied on the judgment of the division bench judgment of this court in MFA number 5732 of 2015, clubbed with RPFC number 125 of 2015, dated 10th March 2023. And submits that in the light of the said judgment, when the wife has deserted the husband, she is not entitled for any maintenance. And the court, without even considering all these aspects, before that, he submits the salary of the husband is 70,000, and the court had granted 20,000 maintenance, which is on the higher side, and he submits that. The order needs to be set aside. Next. When counsel appearing for the respondent wife submits that. In the bank statements, it is the bank statement discloses that in the month of April, May, there is an amount of rupees 18,000 is credited to the account of the respondent. And in the month of June also, an amount of rupees 18,000 is credited. Later, that has been returned
to the institution
on
her termination.
and it has been returned, and they have also filed in the return arguments that where in a particular school, as the teacher was on leave, they have taken her services without any appointment, and only for this brief period of 2 months she worked. It is submitted that while she was at the time of marriage itself, the precondition was she should stop working. As such, she stopped working. Then counsel further submits that the ground of desertion and all other aspects have to be decided by the court during the course of trial. And at this stage, there cannot be a finding with regard to desertion, as the wife is not able to maintain herself and the husband is earning sufficient income. The wife is entitled for maintenance. Next para. Having heard the counsels on either side, peruse the material on record. According to the wife, she is unemployed and the husband is working. Husband also do not deny the fact. However, he has placed before the court to show that between June and December, he was removed from service and was not working.
2022.
The contention of the husband is the grounds that are raised by the husband, the counsel appearing for the husband are: one, when he is not working from June to December, that was not considered by the court. And the second ground is with regard to the desertion, she is not entitled for maintenance. Number three, that she is gainfully employed. Coming to the first ground with regard to the desertion and the judgment that is relied on by the counsel, the said judgment do not apply to the facts and circumstances of the case. Whereas in the judgment referred to supra, there was a finding by the court with regard to desertion. Basing on that, this court has given a finding that she is not entitled for maintenance, which is not, and that stage has not come in this case, and the court has had to decide with regard to the desertion. As pointed out by the learned counsel for the petition, this court cannot appreciate the evidence at this stage whether there is desertion or not. Then coming to the next ground that is raised with regard to her gainful employment, the petition was filed in the year 2021. Yes, Mr.
Yes.
In the year 2021,
please.
It is according to the husband, she is working even from that date, she is gainfully employed. But the material that is placed on record, which he is relying, is about the salaries in the month of April, May, June 2022, and how that amounts are credited into the account of the wife the arguments that are put forth by the land counsel for the respondent and the written arguments that are placed before the family court or convincing. And basing on that, this court cannot come to a conclusion that she is gainfully employed as on the date of the petition and as on the date of passing of the order. Passing of the order. In that case, when the husband is employed and according to the counsel, he is earning 70,000 admittedly, granting of 20,000 maintenance by the court cannot be interfered with. Then coming to the third ground that is raised is with regard to his unemployed, that he lost job and he was not earning from June to December, June 2022 to
April,
December.
no? I'm sorry, April.
April in other places also, right? April 2022 to December 2022, he is unemployed. Considering the fact that he is out of job between April 2022 and December 22, and the fact that wife is having income in the month of April and May, the husband, this court is of the view that the husband need not pay maintenance to the wife between April and January as ordered by the court. In that order, and as far as the maintenance of 20,000 is concerned, it is confirmed. Accordingly, this court is passing the following order. The order of the family court in so and so, dated so and so, is modified to the extent that between April 2022 to December 2022, wife is not entitled for maintenance, and in all other respects, the order of the family court holds good.
My respect to submit should be like reasonable time, maybe 6 months, Your Lordship, 3 months, 6 months time, because 2021 matter where I'm continuing to pay. She's working, Your Lordship.
My Lordship, not even a
Direction may be
single
given because my evidence is completed. Long back, my evidence is complete, my Lord.
No, yes.
At least as the earliest, Your Lordship. That's some observation. Otherwise, Your Lordship, they'll to file statement of objection, they took 4 years, my lords.
I'm telling you, I'm not granting. Even if you repeat it 100 times also, I'll not grant. Because there are the pendency in the Bombay family, Bangalore family courts is huge. The matters of 16 are also pending. How can the court say that 21 be given importance? Yes. Huh? Yes, next.
Serial number 28.
For the petitioner in this case, this is a petition which I am challenging the execution petition, where fully satisfied that the order has passed by the court below, which is not correct, my lord, because I have
come to the impugned order.
Impugned order is the memo of calculation. On memo of calculation, first of all, the memo of calculation file not been filed by the respondent.
Please draw the attention of the court to that particular what is questioned before this court.
This petition, my lord, first in JNWC interim order was passed.
Not that. We will go to your prayer. Please come to the prayer.
The order of the impugned.
Putting aside the order passed dated 7/12/2024 by the so and so. Where is that order of 7/12/2024? Order dated 7/12/2024. Where is it?
Execution.
Where is the order dated 7/12/2024?
Unless execution under that is order, impugned order. Seven 12/24.
Where is that?
There is a annexure D, my lord. Annexure D.
Annexure D order is B or D?
D. Annexure D, my lord. Order on memo of calculation.
Yes. Let's see what did the court say.
The decree holder, the wife has filed the present recovery, pension recovery for total amount of rupees 4,08,641 from her husband. The decree holder in the affidavit document has contended that her husband has filed JWC seeking custody and the said case on her higher. The court granted an interim order maintenance of rupees 3,000 per month for the child and 50% of medical and educational.
Will issue notice. Notice to the respondents, list of the service of notice.
Much obliged.
29. Amresh Angdi.
Yes.
The husband petition, my lord. The wife has filed the divorce petition. After deserted the marriage, immediately after marriage, she deserted, living separately after 12 years. Thereafter, she filed the divorce petition. Again, after 2 years of filing a petition, she filed the maintenance petition, interim maintenance. Interim maintenance was ordered 3,000 to her and child for 10,000 order. Court has not considered the guidelines laid down by the Honorable Supreme Court, reported to 2021-2, without providing the separate
Let's see the order.
liabilities.
Let's see the order.
Into,
No, what is granted? 3,000 maintenance
yes.
to the wife.
Yes.
7,000 to the child.
Yes.
So it comes to 10,000. What is your salary?
He's a coolie, he's not working regularly.
Is it considered? Let us see from the order.
It's not at all considered, my lord. Para 9, my lord. The relationship is also not good, my lord. She is living with some other persons. Para 9.
No discussion on.
No, income, no discussion.
Which court is this?
Senior Civil Judge Malur, my lord.
Senior Civil Judge Malur means comes to. Comes from the Bangalore.
Kolar district, my lord. Kolar district, my lord. Malur.
Comes to us. Comes to us. Administration. Find out. Find out. Let me take this number. The date of order is 11/7. 6/4/2024 is the order.
Date of order, my lord.
6/4/2024. Take this one. Find out. So there is no discussion about your income.
Yes, ma'am.
You were not contesting the matter. You didn't contest the matter.
Contested. The file the objection also, my lord. But court has not considered. She is not living with the husband for the last 10 years. She was having illicit relation with some Arsha.
The child is there.
Yes.
Child.
Child is there. He said, my lord, child is not born to him only. Immediately after marriage, she left the house. She has produced photograph in CD also, my lord, regarding her relationship. And she is having a Xerox center. This also produced. She is earning member.
The present petition is filed. Agreed with the order dated 6/4/2024. Whereby the court had granted maintenance of an amount of rupees 3,000 to the wife and 7,000 to the child. It is submitted that the wife was the paternity of the child is in question, and the wife immediately after the marriage left the husband and residing with and having a relationship with some other person. All these, it is submitted with the land council that the court did not consider the judgment of the Honorable Apex Court in Neha's case, and without any statements of assets and liabilities, and without any evidence on record to show what is the income of the husband, had granted the maintenance. Next paragraph. This court has perused the order passed by the court. As rightly pointed out within and counsel the petitioner, there is no discussion with regard to the income of the husband, and none of the aspects were discussed by the court. And court had just like that granted the maintenance. In the activity of the matter, there shall be stay of all further proceedings. In so and so and so. The notice to the respondent.
Pray for interim stay, madam. Pray for interim stay. Interim stay, madam.
Stay is granted. Till number 30, Kapil Dixit, for petitioner.
My lord, for the petitioner, my lord. My lord, this case is filed for expedite of the MC case, my lord.
MC is of which year?
2021, my lord.
Which court it is?
It is before the additional senior civil judge, Bangalore Rural, my lord. My lord, there are no children out of the wedlock, my lord.
Not about the facts of your case. It is about the pendency that's there. The Bangalore courts are still 16, 17 is still going on. And how can there be a direction in your case? In every family type case, in every matter, the problems are like the same. The petition is filed seeking seeking a direction to the family court to expeditiously decide the pending MC, that is MC number. So, like, or else you do it. The writ petition is filed seeking the following relief. Land counsel appearing for the petitioner submits that. That the MC is filed in the year 2021, and in the light of the difficulties faced by the petitioner, there may be a direction to expeditiously dispose of the matter. Next one. This petition is pending before the 7th Additional Senior Civil Judge, Bangalore Rural, and where several petitions are pending. Hence, this court cannot give a direction to the court to decide a matter of 2021 in priority when other matters are pending, when the matters which are much older are pending before the court. In the artery of the matter, this court finds no reasons to pass any orders to expedite the hearing and accordingly dismiss.
Till number 31,
Much obliged.
Naganandini.
Yes.
This petitioner has filed challenging the order passed by the senior civil judge and JMFC Odalkere on the application under section 24 of the
What is the maintenance that is
10,000 rupees has been ordered by the honorable court. There is no child here. The petition is filed for the restitution of conjugal rights, and the petitioner is working as a coolie.
Please come to the order. Let's see the order.
Page number 54, your Honor.
54. That's in Kannada.
Yes. I approved a
Pay half of the amount.
yes, sir, 5,000 rupees.
They submitted that. The court had granted 10,000 as maintenance by way of the order impugned, dated so and so. Then counsel submits that the petitioner is working as a coolie and is not in a position to pay the amount. Considering the submissions, there shall be stay of all for the proceedings in 5,000. And the arrears also at 5,000 within 8 weeks. Yes. Notice to the respondents.
Yes.
And a default order as far as. Yes.
The petitioner, my lords.
Sunil Kumar
My
Patel.
lords. It's wife's petition, my lords. Wife in a divorce proceedings initiated by husband, wife files an IA seeking a prayer to stop the further proceeding in light of the non-payment of maintenance by the husband, my lords.
Please come to that.
Please, my lords. Impugned order is at page 11, my lords, annexure A. Ink page 11.
Relevant?
Relevant starts from, my lords, ink page 17. About 8 lines from the bottom, my lords. In case of the wife files petition for divorce, the husband fails to pay interim maintenance amount, then the defense of the husband can be struck off, strike out for non-payment of interim maintenance. With due respect to such judgment, will not come to the aid of respondent in this case, because in this case, no interim maintenance is ordered in favor of the respondent. Respondent is seeking stay of the proceedings for non-payment of arrears of maintenance in CME so and so. That too pending before first additional principal judge, family court, Tumkur. If the petitioner fails to pay the interim maintenance amount ordered in this case, then certainly the above said judgment would come to the aid of the
seeking stay of further proceedings.
of MC, my lords.
No, in some other case, in the.
No.
No, read it.
Please,
read it at page 18.
My lords.
Second line, the respondent seeking.
Respondent seeking stay of this proceedings.
That is MC proceedings.
MC proceedings.
Then read it.
Yes, ma'am. This proceedings for non-payment of arrears of maintenance amount in CMIS 126 of 18, that too pending on the file of first additional principal judge, family court, Tumkur. What has happened, my lords, in CMIS proceedings, maintenance was ordered. That also I have produced at page number 58. Your lordship will get 51. 10,000 is what ordered. That has attained finality, my lords. In the meantime, husband initiates the divorce proceedings because previously had unsuccessfully attempted to divorce proceedings. That was withdrawn.
Order of the court is right. I can understand.
Yes, ma'am.
In the maintenance case, in the MC that's filed for divorce,
yes,
he is pursuing the MC.
Yes.
And the maintenance is granted in the MC under 24. And in that case, if you say without paying the maintenance granted, you are pursuing with the matter, I can understand it. But not this.
Here, the fact is the maintenance ordered in CMIS.
It will be complicating everything by passing that kind of an order.
That is what my.
Everything given by the judge is perfectly right.
Because maintenance.
Because I have passed this order, I know what is that.
Yes,
order.
yes. Your lordship's
yes.
reported judgment is there. But the only factual difference is here in this case, CMIS is in CMIS proceedings, maintenance is ordered. I understood,
all
my
the
lord.
things together. Then it will become more complicated if that kind of an interpretation is given.
My request is I'll seek instruction to whether to withdraw it or not.
Please say.
Kindly have it on Monday, my lord.
Monday.
Much of it.
Cell number 33. E.K. Shiva Prakash.
For the petitioner in this case, Your Lordship, as against the order passed by the court below, under section 24 of the application filed by.
How much is granted?
6,000, Your Lordship.
What is your income? You're seeking enhancement?
I am seeking enhancement.
Notice? Notice if you're seeking enhancement.
Yes, Your Lord. And also stay the proceedings.
Why?
What has happened, Your Lordship, intentionally he has left the house.
No.
Your Lordship may kindly appreciate.
No, you're seeking enhancement of maintenance. Why would the court stay the proceedings before the trial court?
Now it has reached the stage of cross-examination of.
No, that's not the order.
And kindly an order may be passed to give the copy to the counsel before the trial.
Yes, instead of notice, in addition, we'll have order notice. The learned counsel for the petition is permitted to serve the hand summons on the counsel appearing to the respondent before the trial court and shall file a memo to that effect. Once the memo is filed, this is matter.
Cell number 34. Jagdish JR for petitioner.
Yes.
This case, we are challenging the order dated 8/11/2024. The reason being the application was filed in October 24. I had filed a petition for divorce that was decreed.
So what is the prayer in this?
In this, I am seeking to quash that order wherein my interim maintenance was ordered from the date of filing of the petition. The application itself was in October 24, seeking interim maintenance. Court orders the maintenance from 2020 when I had filed the petition.
for divorce.
Yes,
She filed the IA in the month of October.
24.
The present petition is, let's see the order.
Yes, ma'am.
You are not agreed with the amount of maintenance.
No. It is the
Where
time
is that
period
order?
from that
Where is
annexure
that?
A, my lord, page 10.
The petition is directed to pay some more rupees 7,000 monthly for the date of this petition.
No, this petition, not the application, this petition they say. Petition was in 2020.
No, the
I
court-
filed the petition for divorce.
And this petition means this application for maintenance. Why are you interpreting it that way?
No, not that way, my lord. The court itself has made that way. And for that, they have filed a miscellaneous for recovery, calculating it from the date of,
Where from you get this date of application for maintenance?
yes, my lord, I did not get it.
Date of application for maintenance.
Not in the very petition, my lord. Annexure G is the application.
Annexure
G.
Please point out the page number.
There's some confusion in that. 54 is the page in mine. There were some typing pages which were filed.
It is filed on 14/10/2024.
Yes, yes, my lord. On the very next date, the petition is dismissed.
No, where is it?
Application is filed on that day only. What happens, my lord? My petition is filed for decree of divorce.
You are referring to the objections of the respondent.
Objection as well as the IA both were filed on the same day.
Where is that IA?
IA have filed it, ma'am.
It is not there. You are referring to page number 54.
Yes, ma'am.
Look at page 54. It is only objection to the main petition.
No, objection as well as both are filed on the same day, ma'am.
Where do you get the other application?
Kindly pass on, my lord. Just my pagination have made.
Yes, next.
Serial number 35 urgent. Serial number 36. 36, Anish Acharya.
Press time for it's on a
Aisha.
hearing on admission, my lord. Press time, my senior is on a.
Matter of 2 weeks. Next 37.
Yes. Serial number 37,
I
Sidmalappa.
seek for a 2 weeks short accommodation, Your Honor. Since most of the annexures are in Canada, I have filed for a
List this matter
translation.
after 3 weeks. At the request of an counsel to the petition.
Match.
Yes, 38.
Serial number 38. 38.
My lord, for the respondent. The arrears are about 8 lakhs.
Says stay in this.
There is a stay, my lord. First it was
No
vacated.
representation for the petitioner. This is matter tomorrow for dismissal.
Yes.
Counsel for the respondent is present.
Serial number
39.
39.
Can it be taken up on Friday, my lord?
Friday.
Apologies.
Yes.
Obliged.
39.
Serial number 39, Sheshadri NS.
I'm the petitioner in this case. Husband revision petition, 4,000 rupees is granted, my lord. However, there is a case for divorce between the parties. I have not been informed regarding the outcome of that divorce petition. A week takes.
Submitted that as per his instructions. The parties have obtained a divorce and
No, my
for
lord.
getting
I
instructions.
have to ascertain minutes.
That's what, but to get specific instructions, the council seeks time, just after 3 weeks. Yes, next.
Serial number 40, 41 urgent, 43, 42 disposed, 43. Serial number 43, Kalpana PV,
Insufficient, madam. Serial number 42,
disposed.
It's adjourned.
disposal, but early morning I am not attending. So one direction is given. Petition is deposited 75,000 rupees in this honorable court. Kindly direct to release the amount to respondent.
What happened to 42?
It became infectious over. Earlier,
So that I understand. The matter itself is now, the main matter itself is disposed of. Your rights must have been displaced. In fact, that should be, there should be a direction to give it back to them, not to you. That
No,
I have to, then you do one thing, 42 42. List this matter tomorrow. Let the council be here.
Tomorrow.
Because it is already heard in the morning, it is disposed of.
Please.
42 tomorrow.
Yes, ma'am.
Yes, 43.
Cell number 43.
My lord, this is a husband petition, my lord. My lord, the wife had filed the marriage between the
Where is
part.
the counsel for the respondent? We'll have it tomorrow.
Yes,
No, counsel of the petition is present. No representation for the respondent. Let's this matter tomorrow.
much.
Cell number 44 urgent. Cell number 45. 45.
Tomorrow, no representation. But dismissal tomorrow. Then 46.
Cell number 46. Gaurav Subramanya.
Husband petition.
46.
Yes.
Husband is a petition, my lords, wherein challenging the order of the maintenance which has been ordered.
How
at
much is
page-
granted?
At page number, my lords, 13, my lords. The order dated 1/3/2025.
How much is
15,000 has
granted?
been ordered, my lords, no children's. Second marriage for both the petitioner respondent, my lords.
15,000 is ordered.
15,000. has
What is
been
your
ordered.
salary?
My lords, as per the assets and liabilities and also as a document, my lords, it is 15,000, my lords.
The salary itself is
15,000. It is, he is only working as a AC mechanic, my lords. And also,
half of it. Half of it.
Seven.
50%. Then counsel for the petitioner submits that. The court had granted 15,000 to the wife as maintenance, and the husband is earning 15,000. Considering the submission, there should be stay of all further proceedings. Condition that he shall deposit 7,000. 7,000 by 5th of every succeeding year. He shall continue to deposit 7,000 by 5th of every succeeding month. And the arrears at the same within 8 weeks. Notice.
much.
Yes, next.
Let's.
No. Family courts, whether it comes with us or not is the point.
No, these comes under.
Oh, it is not a family court. That's what I'm saying. We are the ADM of 32 family courts. It is. Yes.
Let's one submission. Hand delivery may be permitted.
Hand delivery.
Serial number 47 urgent, 48 disclosed.
Permission. Serial number 45.
Yes.
40, 45. I'm ready to address my arguments, my lord.
79.
To the 5.
Yes.
45.
45. Tomorrow.
The petitioners are the children of respondent, my lord. The respondent has filed a petition under section 125 of the CRPC.
Who is the father?
Father, my lord. And the Honorable Trial Court passed an order
Yes.
directing the petitioners to pay monthly maintenance of rupees 20,000 jointly and severally. And also direct the petitioner to pay cost of the petition of rupees 10,000. So that judgment and order is under challenge by the petitioners, my lord.
By the children.
Pardon, my lord?
By the father or the children?
By the children. Now in this case, my lord,
P number.
3.
P number. What are they doing?
The first petitioner is doing a marble business. First and third petitioner. And second petitioner is Qatar.
What is he?
Qatar. Foreign, Middle East.
Oh, he's in Qatar.
Qatar. Yes. Now here in the case, my lord, the respondent himself left the company of the petitioners. And he has left his wife also. And he has filed a OS number 58/2023 against his wife for restitution of conjugal rights. That case came to be dismissed on 27/8/2024. It is marked as Exhibit R4 in the present case, my lord. and the petitioners are taking care of their mother. And even today, they are ready to take back their father. Father himself left the company of the petitioners. That is the case, my lord.
No, it's not that you cannot say that you stay with me, then only we'll take care. Maybe for staying with you,
He himself left the company of the petitioners.
No, he doesn't have.
And he left his wife also.
No, he doesn't have the favorable circumstances to live with you.
And he left his wife also, my lord. And the petitioners.
For all to appreciate all this, the other side should come.
Yes.
Notice should go.
Yes.
On 50% will grant.
25%, my lord.
The land counsel appearing for the petition submits of the court are granted 20,000 maintenance to the father, and the petitions before this court of the three sons. It is submitted that the father has deserted the mother as well as other family members, and in fact he has filed OS 58 of 2023 seeking the restitution of conjugal rights, and the same came to be dismissed on 27/8/2024. It is submitted that the children are ready to take care of the father, and in fact the father is not interested to stay with the children, and the court, without considering all these aspects, granted the maintenance of an amount of rupees 20,000. Considering the submissions, there shall be stay of all further proceedings on the condition that the petitioner shall pay an amount of petitioners shall pay an amount of rupees 10,000 by 5th of every succeeding month, and the arrears also at 10,000 within 8 weeks.
10,000 arrears, my lord.
Arrears also at 10,000.
Yes.
Counted 10,000
Yes.
within a period of 8 weeks. Default
No,
order.
yes, my lord. And the respondent has already filed semis number 53/2025 for execution.
Because when there is an order of stay of all further
Yes, yes,
proceedings
madam.
of this order,
Yes.
that they cannot.
Yes.
Yes.
Much obliged.
Cell number 49,
So 48,
Samurthy MR,
48,
40,
48.
48 dismissed as infectious.
Yes.
49,
This matter become infectious, my lords.
Why the MC is disposed of? Why it has become infectious?
I don't know.
It is
But I
submitted
have-
that the writ petition has become infructuous as the main matter itself is disposed of, accordingly dismissed as infructuous. Case 50.
cell number 50, Gowda for
Representation is this matter after 8 weeks.
cell number 51, Sebastian MA,
Hearing for respondent, my lords. My lords, in this matter, there was an interim application which was dismissed by the family court, based on which it was on appeal, and the main petition is dismissed, my lord. So this petition becomes infectious.
This is maybe based on the interim order. 20,000 rupees was allowed.
No. What he's saying is the main petition itself is disposed of. What remains in an interlocutory order? It merges with the main order.
I would have no.
When was it disposed of?
It was disposed in 2023, my lords. In 2023 itself, it was disposed.
That is, what is this main name petition is? See miscellaneous number 533.
Yes, my lords. Yes, 533.
It is submitted that the council appearing for the respondent submits that the present writ petition is filed, questioning the order passed in see miscellaneous number 533 of 2018, passed by the which court? Principal Family Court at Bangalore. It is submitted that in the year 2023, the main petition itself is disposed of by the family court, and as such, nothing survives for consideration in this petition. Accordingly, the petition is dismissed as infectious.
cell number 52, Ketan Kumar, petitioner,
Husband's petition, my lord. My lord, Warden Bench of Dishonorable Court on
Bhagirathi,
31/8/2021, my lord, directed the respondent to file affidavit stating on oath, saying that funds where she was invested, my lord. Kindly peruse order dated 31/8/2021, my lords. During the pendency of the proceedings before family court, respondent
Represented by caveator, no steps need to be taken for notice. This court on 31/8/2021 has passed an order directing the respondent to state on oath on the next date of hearing the holding of property and the funds in the bank, financial institutions or the like, including investments in shares, debentures, stocks, and failing which an adverse inference will be drawn against the wife. No wakalat is filed by the caveator.
On that day, my lord, respondent represented by the advocate, my lord.
In spite of the order dated 31/8/2021, so far, no such affidavit is filed by the respondents and there is no representation on behalf of the respondent. And finally, for giving a final opportunity, list this matter on 18th or else the orders will be passed based on the material on record.
Interim order may be extended, my lord.
Interim order is there.
There, my lord.
Then interim order earlier granted is extended. List this matter on August 4th.
Please.
Yes.
Cell number 53. B. Ravindranath.
My lord, in this matter was listed, matter was addressed in arguments, my lord. It was posted for judgment. Thereafter, it was recalled. Now that it's going on, my lord. When once the matter was posted for judgment, it may not be recalled, my lord. Hence, I have questioned the impugn order passed by the family court, my lord.
Judgment is motu recalled.
Posted for judgment, my lord. Judgment was not yet passed. Arguments was addressed, he was placed in.
Judgment, then what the court said?
My lord, I'm
No,
not.
posted for judgment.
Yes, my lord.
Then what happened?
They have filed an application for recalling, my lord.
For on what ground?
They have placed an ex parte, my lord. Notice was served, they have not appeared before the court. When the matter was posted for judgment,
They filed an application.
they filed an application for recalling, my lord. That was recalled. Yes, my lord. That was recalled, my lord.
Where is that order? Let's see. You don't have the file?
I don't have file.
This is matter after 2 weeks. Yes.
My lord, next.
Huh?
Kindly have it on Friday, my lord.
This Friday?
This Friday.
This on Friday.
Yes.
Yes.
Cell number 54. Jai Sima KP.
Presentation, this matter on 2nd September. Don't extend interim order if it is there also. Yes, 55.
Cell number 55.
This also same.
Serial number 56 default, 57 adjourned, serial number 58. Raksha Kirtana.
For the petitioners, my lord, unless there is settlement talks.
These kind of matters are added. Old matters. All these old matters were added. You should have the question. No, don't ask them not to add these old matters. Let them post the 24 matters.
Madam.
24, 25 matters will be post, not this old matters. Yes.
It's for the petitioner, the settlement talks between parties, my lord.
In which case?
58.
Settlement talks are going
Yes,
on.
ma'am.
It is submitted to the settlement talks are going on. This is matter for 2 weeks. It's 59.
59 adjourned, 60. Serial number 60.
There's also no representation post in the month of July. Give some date.
Serial number 61. Serial number 61. Sonia Rajesh.
Going for the petitioner, my lord. You know, we were directed to provide the respondent copies of the assets and liabilities filed in the trial court. In the last date of hearing, I've already submitted that to the respondent. And there is an interim
The party
order.
in person comes for the petitioner is present list on 25th of June.
Interim order may be extended, my lord.
Interim order earlier granted is extended. Yes.
Highly obliged.
List number 2. Parted matter, serial number 1. Pradeep B. For appellant, V.N. Madhava Reddy.
Let all these MFAs, parted matters, 1, 2, let continue tomorrow. And 3 also. This 4 further hearing matter, delete and post before the court having roster.
Serial number 3.
Huh?
Serial number 3 list.
It will come tomorrow. You're done?
Passover.
Where is your matter?
Passover matters.
First matter.
Huh?
Second is first matter.
You're ready?
20 some not well. Not well today, kindly have taken.
Tomorrow
Next week.
or next week?
Serial number?
One.
One.
One next week. Yes.
Password 20.
Oh, that will be called.
One.
No, no, no. Next week is saying. Or shall I release it from Parted? Oh, it is Pradeep's matter. You are for the respondent.
Respondent.
Next week. No, not next week. No, don't release.
Yes.
In Parted on. Yes. Yes. What are the
The
Passover
Passover
matters?
matters. Serial number.
Pagination ಇಟ್ಟುಕೊಳ್ಳಿ. ಅವತ್ತು ಒಂದೇ ನಿಮಿಷ ಹೀಗೆ.
One more Passover. Serial number 20. Serial number 20 Passover.
For the petitioner in the case.
Payment is due, my lord.
But I'm unable to contact the petitioner right now. Seeks 3 days time, my lord.
This is matter on Monday. We'll grant it.
Friday.
This matter on Monday. At the request of Glen Council. Yes.
Not in this.
34.
The IA was not filed as on that day because the court had not given. But in this, we can see that the IA 57 page number, 55 is the order sheet. 57, it can be seen that the IA was also filed along with the objections. Respondent counsel present, Passover for objections. Case again called at 11:35 PM. Respondent present, objections filed to main petition along with application under section 24 of the Marriage Act.
Counsel for the petitioner submits to the court and granted maintenance of an amount of rupees 7,000. Where is that?
Annexure A, my lord.
Granted an amount of rupees
7,500.
an amount of rupees 7,500 to the respondent per month toward expenses of the proceedings and monthly expenses from the date of the petition, that is MC number 121 of 2021, which is filed in the year 2021. It is submitted that when the petition itself is filed on
The application is filed, my lord.
when the application is filed in the, on, what is the date you said?
19/10/24.
19/10/2024, they are not entitled for the amount from the date of the petition filed by him. Considering the submission of the Land Council, the respondent is entitled for the maintenance from the date of the application until further orders to be passed by the court. List this matter after service of notice to the respondent. No, the note, court notice to the respondents.
Which oblige.
Yes, Pradeep, what happened to that matter? He's seeking adjournment.
Second list to second.
Huh?
Chief has heard this matter sometime.
Then why is he asking adjournment?
Second list to the second one. Madam, that's Chief has parted because of he has not represented on the day.
Yes. No, just please, no, court has already heard. We'll see what is done. And whether, how it is not acceptable. If it is not, then for hearing your arguments, we can have some other day.
Some other date, madam. Today not well.
No, no, you don't have to argue. First of all, you don't know what has transpired on that day. Let me look at the file. Give that first matter, MFA 944.
What happened this matter? I received today file, madam.
1 minute.
Second list ಎರಡನೇ matter ಏನಾಯ್ತು?
1 minute, I'll tell you.
Please.
Serial number.
One.
9447 MFA.
9.
That day you were not there, that's why it's adjourned.
Earlier appearing in some other council, today I received the paper.
So what is this matter about? That we will see.
Tax also is not known.
Huh?
My lord, here, my lord, first one complaint has been large stated that my lord injured himself was riding the motorcycle.
Oh. Then
Afterwards, my lord, again one more FIR has been.
We'll give him an opportunity till Monday. Let it come on Monday.
Monday, Monday some other parted matter is there, my lord, next week, my lord.
Then?
After 12th, my lord.
No, not after 12th. We'll have it on, then after 12th, we'll have it on 13th. 13th,
Please.
under the same caption. Any signatures? You just come to the chamber with regard to the list. Right. Any of why there are so many other family court matters parted. Why are they not listed? Your parted matters are also there.
No, my lord, this one, this is the only.
Is the only one. You just ask them to list all other family court matters parted. So that.
First is serial number 6. Serial number 6, I needed an adjournment.
Serial number?
60. List number 1. I need an adjournment.
16.
What happened to that?
The regular conference, unaware.
What happened to that? 16? It is adjourned. What do you want?
Nothing. I apologize.
Serial number 4, sorry. Serial number 4 in list number 2. When we have it next week, I shall file the statement of objection.
I think I have released it from further hearing. It will come before the court.